So the ATF just suffered another major loss in the Texas case challenging the ATF's new rule on frames and receivers. But the ATF continues to resist taking that loss. So let's talk about this. But real quick before we jump into this video, if you think the ATF needs to be done away with, go ahead and hit that like button and subscribe. Also, I want to thank the sponsor of this video, which is Sonoran Desert Institute. SDI is an accredited online college that helps students learn these skills and techniques they'll need to be successful in the firearms industry. So if you enjoy gun repair, ballistics, and learning about firearms, SDI might be a good option for you. To find out more about SDI, you can visit the website linked down below, and thank you again SDI for sponsoring this video. How's it going, everyone? My name is Anthony Miranda. I am a licensed and practicing attorney in the state of California with an emphasis on Second Amendment rights. I've been part of Second Amendment litigation both at a state level and a national level, while serving as a staff attorney with the Firearms Policy Coalition legal team. As I mentioned in the intro, in this video we'll be discussing how the ATF suffered another major loss in the Texas case challenging the ATF's new rule on frames and receivers. Blackhawk Manufacturing Group, aka 80% Arms, was just granted a preliminary injunction by the court which bars the ATF from going after the company and its customers as well. The ATF did not want 80% Arms to be allowed into this case as a new plaintiff because the ATF feared that Blackhawk Manufacturing, aka 80% Arms, if added into this case, would be granted a preliminary injunction similar to what was granted to another company called Tactical Machining. And that is exactly what has happened in this case. However, the ATF does not want to accept another preliminary injunction loss, so they are now appealing that preliminary injunction, the granting of that, and are now taking this up to the Fifth Circuit. The case we're going to be talking about in this video is called Vanderstock v. Garland. This is a lawsuit filed in the Northern District of Texas against the ATF and their new rule on frames and receivers, which went into effect in August. This whole lawsuit arose out of the ATF's creation of a new rule, a new regulation of unfinished frames and receivers. This new rule by the ATF is essentially a restriction on the sale of 80%er kits, 80%er unfinished frames or receivers that come with jigs and other items as well, including instructions. This new rule went into the regulatory definition of a firearm and changed the definition through a web of references to include 80%er kits to actually now be defined to be actually firearms. In the lawsuit, the plaintiffs also requested a preliminary injunction from the court to enjoin, i.e. halt the enforcement of the ATF's new rule while this case is making its way through the process. On review, Federal Judge Reed O'Connor granted a limited preliminary injunction against the ATF. Looking at the ATF's rule on frames and receivers, he found that it is facially invalid under the plain text of the statute and that Congress did not grant the ATF authority to regulate these types of items. So he granted a limited preliminary injunction in favor of one of the plaintiffs, Tactical Machining. Later, he expanded the injunction to also protect the individual named plaintiffs and also the customers of that company, Tactical Machining. After that, Blackhawk Manufacturing Group, aka 80% Arms, sought to intervene in this case as a named plaintiff. And as soon as 80% Arms was allowed into this case as a named plaintiff by the judge, and they were added in, they then sought a motion for a preliminary injunction to prevent the ATF from enforcing that new rule on frames and receivers against their company and customers as well. They sought the same type of injunction that the court already granted to Tactical Machining. Of course, the ATF was very much opposed to that, and they opposed that motion for a preliminary injunction, but ultimately they lost once again. We received an order at the end of last week from the judge in this case, which was granting 80% Arms the same preliminary injunction that they already granted to Tactical Machining. So here's what the court said in that order. Judge O'Connor stated, rather than recite its previous analysis with respect to the interpretive claims verbatim, the court incorporates by reference the reasoning in its first opinion. To summarize, the final rule purports to regulate firearms parts, including incomplete, non-functional receivers and weapons parts kits, contrary to the plain language of the GCA, which confined ATF's authority to regulation of firearms, a term clearly defined by the statute. Moreover, the final rule's expanded definition of frame or receiver to include partially manufactured, non-functional receivers within the meaning of firearms, contrary to the GCA's clear statutory definition, is facially unlawful. Judge O'Connor in this case goes on to state that Blackhawk Manufacturing will clearly suffer irreparable harm and that he already has gone through that and has come to that conclusion when he decided the prior preliminary injunction and the prior expansion of the Tactical Machining preliminary injunction. Then the judge points out how absurd that the ATF's claims are that there will be no injury to Blackhawk simply if they decide to comply with the new rule. So here Judge O'Connor dismisses this ridiculous argument that all the company needs to do is simply bend the knee to the ATF and comply with their rule, and then they won't suffer any harm. Then the judge also called out how the ATF blatantly misrepresented the type of protection that the company was actually requesting in their motion for a preliminary injunction. He stated, "Finally, while the government argues that Blackhawk affirmatively seeks to protect the ability of potentially dangerous individuals such as felons, unlawful drug users, and domestic abusers to obtain items and kits that can readily be converted into functional firearms, Blackhawk makes no such request." No less than 3 times, Blackhawk reiterates that it seeks injunctive relief that matches the relief currently provided to tactical machining. Therefore, Judge O'Connor found that this whole public interest argument of preventing prohibited people from being in possession of these types of items is not a valid claim, because that is not what 80% Arms is actually seeking in this preliminary injunction. They are only seeking the same type of relief that was already granted to tactical machining. Therefore, the court found that Blackhawk has shown it's entitled to a preliminary injunction against the defendants, the ATF, and their enforcement of the final rule. Now, 80% Arms already has indicated on their website that they are now once again selling these devices. How long that's actually going to happen, that's kind of the question. But it appears from the website that 80% Arms is now actually selling these items, and they have that protection against the ATF, and their customers have that protection as well. Now, one thing I want to note is that the ATF has already filed an appeal in this case. They're already seeking the Fifth Circuit review of the granting of the preliminary injunction. The ATF did the same thing when tactical machining was granted the preliminary injunction, and they will likely also seek a stay of that judgment of Judge O'Connor, of the granting of that preliminary injunction. So the ATF goal right now is to oppose the granting of that preliminary injunction, take this up to the Fifth Circuit, and get the Fifth Circuit to put a stay on that determination. So this is something you will definitely want to keep your eyes on if you're interested in purchasing these types of items, especially since right now protections are in place, but that could drastically change overnight, especially if the Fifth Circuit puts a stay on their judgment. Also, for those people in states like California, I want you to know, and a lot of you have been asking, how does this affect those states? In reality, California has its own state level laws. It has its firearms precursor part laws. So the ATF ruling here, the injunction against the ATF's new rule on frames and receivers is not going to affect those state level laws right now. So just keep that in mind. Just because this is lifted as far as the ATF rule, you still have state level rules like which exist in the state of California with our firearms precursor laws. Regardless, this is great news coming out of the state of Texas, but the ATF is now going down the road of trying to fight this at the Fifth Circuit level. So that's where the battle will currently take place. So if you have any questions, go ahead and comment down below and I'll try to answer the best of my ability. Also, like this video and like support the channel, when the best way to do that is to like, comment, and subscribe. All those things help to fuel the algorithm or fuel Al Gore's rhythm. It adds fuel to his jet and signals to YouTube that you guys see value in these videos and in this type of 2A news. Again, I want to thank everybody who likes, comments, subscribes, who hits the notification bell, who shares these videos. You guys are directly impacting these videos, impacting this channel, and helping me to reach and educate more people than I could ever do on my own. So as always, thank you all for watching. Don't forget to like and subscribe. And never forget, this nation was built by armed scholars, and this nation will be maintained by armed scholars.